Okay, very good. Good morning, I should say lunchtime, everyone. My name is Mike Daiello. I'm a real estate attorney for property owners. My office is in Philadelphia, and I'm happy to be joined today by Kelly Steen of Keller Williams. We're presenting today on the topic of avoiding pitfalls of buying and selling inheritance properties. So thank you all for joining us. We have a couple of things I think will be helpful for you today. First, today's presentation, it's about 30 minutes long, and we're going to have a Q&A session throughout. So if you have any questions about anything that we are discussing, just feel free to ask, or you can type it in the chat box if you're not able to talk on the audio for some reason. And secondly, I'm going to give away a free guide to you after today's presentation. It's a guide that's going to be like an educational packet for anyone who is interested in dealing with inheritance properties to help you avoid pitfalls. And it definitely covers some of the topics that we'll talk about today. So it'll be like a little reference guide for you in your area of real estate. So again, thank you all for joining us. Kelly, why don't you introduce yourself and tell us a little bit about what you do?
Sure. Hi, I'm Kelly Steen. I'm a residential realtor here in Keller Williams and Bluebell. And I've been doing it since 2007. And every year I do a handful of estate sales. And I wanted to team up with Mike here because he knows a lot about that. And I felt like a lot of the estates I deal with, the executor, the trustee, maybe hasn't sold a house ever or not in a couple of years. So they just need a rundown of the basic selling process and what to expect. And that we always go through the conversation of what to do, make repairs, make improvements, sell as is, and kind of what that looks like. So we'll go through that all today as well. So Mike will start us off. We're just going to ask a couple questions about, so how does someone get started? So their loved one passed away. How do the heirs sell the property and get that process started?
Sure. Yeah, thank you, Kelly. So I'll talk today a little bit about the legal side of things, and Kelly will talk about sort of the basics of selling a property from the transaction perspective. So when you pass away, anyone who has died can no longer handle any legal or financial affairs through the court system. So what that means is that if you die, someone has to raise an estate for you. An estate is sort of like a little company. It's not a legal entity like a company, but it's a way for someone to be appointed as administrator of the estate so that the person who's the administrator can act for the person who passed away. Now, what that involves is going down to your local register of wills. In Philadelphia, that's in City Hall, and you take the death certificate and you take some other information about the person who passed away, and you take it all down to the register of wills and seek appointment as an administrator. So what you would typically do is bring the will, if there is one. You would bring information about bank accounts, information about properties they own, and you gather all the information about the deceased and you seek appointment as administrator. And whoever that administrator is, or if there's co-administrators, those people can handle the affairs, such as listing and selling a property. That's the basics of how you get started with probate.
Got it. So can you explain a little bit of how much that costs and the basic things? Did you?
Yeah, so like when you are dealing with probate estates, there's always going to be taxes, and that's unavoidable, unfortunately. And the Register of Wills is going to charge you a couple of different things. One is a probate fee. A probate fee is basically the fee that's collected to set up the estate and have the estate administered through the Register of Wills. And then there is inheritance taxes. So in Pennsylvania, we do have inheritance taxes. The amount is based upon the value of the estate and who the relationship is between the person who passed away and the person who would receive the proceeds from the estate. In other words, if the heir to the estate is the spouse, the tax rate is going to be different than a child, which will be different than someone who is collateral, like a brother or sister, an uncle, things like that. The tax rate runs roughly between 4% and 15%. And again, it's based upon the relationship of the person who passed away. So that's the basics. It's interesting.
Yeah.
So when you go through this thing, and now you have the property, the estate set up, and now the property can be sold. The question starts becoming, okay, what's the best way to do that from the perspective of a realtor, who's someone who is interested in selling the property? How should they go about doing that? So Kelly, can you tell us what are some of the pros and cons of selling a property wholesale rather than advertising to the mass market?
Yeah, so great question, and that's always an initial question I have with the estate. So as the executor of the estate, you want to talk with an agent early on to talk about your pros and cons. So it's really going to depend, and I always say it depends. It depends on the property, the condition of the property, depends on the current real estate market, depends on the location of the property, and what is owed to the estate, like on the estate. So do you even have funds to make repairs? So it's really specific to that situation. I will say it often, in our current market, inventory is very light. It's very scarce, and it's leaning towards the seller's market in most of the Philadelphia region. So houses that typically would need repairs and a lot of work are actually selling for a pretty good price. So again, it depends on the condition and your specific market. Wholesalers and investors can be from the MLS too, but for the most part, if you get like a mailer to the house or a call from an investor or a wholesaler saying, hey, we'll buy your house cash as is, they're going to offer a lot less than if you went to the masses, to the mass market, the MLS. They're looking at their after repair value. You might hear them say ARV value. And so it's a numbers game to them, what makes sense. And that process might make sense to you as the executor if you live out of state, out of country, and you don't feel like dealing with anything. They might even buy it with all the belongings in there and get rid of it themselves. So it really depends on your situation and what your time and energy costs to you too. So I will say that if you're local and you don't have to do a ton of repairs, it might make sense to market on the MLS and hire someone. You'll just really want to run those numbers and scenarios with your agent. So with that said too, early on, you'll speak with an agent and you need for your estate the estimated value at time of death. So you'll want to talk with someone early on and getting that put together for your inheritance tax, and or attain an appraisal. So talking with a professional early on, either way, to get an idea of the value will really help you determine, hey, what makes sense for us to do here.
That's good insight. Yeah, thank you, Kelly. That's good insight.
Thanks.
I know it's broad because it's so specific. Depends on the actual house, but.
What things should someone who is an administrator of an estate or an heir do to gather documents and prep for you to list the property so that there isn't roadblocks with the title company later on?
Yeah, so either way, if you sell to a wholesaler or through the MLS with a traditional buyer, you're going to have to provide clear title, and clearing the title over the property. You have to go through the probate process for that, which Michael already went through. The inheritance tax will have to be paid. You'll have to provide proof that it was paid already, but most likely it's going to be paid with the sale of the property. So you'll work with the title company, and they will help you determine the inheritance tax that's owed. And they'll actually hold an escrow. They'll pad it a little bit, usually 1.5 times the amount owed will be held in escrow until that final register of wills determines the final inheritance. And Michael probably knows more about that. You'll have to pay property taxes, and those will be prorated. So you have to provide proof that if property taxes were already paid or not paid. So they just determine, again, clear titles. Your taxes have to be paid. All liens have to be paid off on the property.
Okay.
Another thing that has to be filled out, whether selling to a wholesaler, investor, or through the MLS, is Pennsylvania requires the seller property disclosure to be completed with any transfer of sale. So I'll pull up what that kind of looks like to give you an idea. So this is, probably see all mine. If the house was built before 1978, you have to disclose any residential lead-based paint in the property. And then the seller property disclosure, if you ever sold a house before, it's required for Pennsylvania. It's about 10 pages long. It is 10 pages long. It checkbox yes or no, what you know about the property. And as the administrator, you do have to fill out to the best of your knowledge, but there is a section on the last page that you would sign off on if you don't know of anything, or what you do know. So this section, this box right here, is disclosing what you know and that you are the trustee or admin of the estate. Which leads me to, Michael, what, in the legal side, filling out this property disclosure, what are some things the estate should think about when doing so?
Yeah, that's a great question.
Yeah, that's a great question.
I'm going to mute you just a second because it sounds like there's some feedback, Kelly, but only while I answer the question. So when you are dealing with a sale, you have to be honest in disclosing things that you know about the property that could become a problem for somebody who is the buyer of the property. This is really important because if you fill out the disclosure form as the seller and you don't list the things that you know or at least should know of that are readily apparent about the property, you could eventually be sued in court by the person who was disappointed when they found out, hey, there's some mold problems in my house, there's water leakage into the basement. And if that person can prove in court that you're responsible for not disclosing things that you knew or should have known about the property, you could be on the hook for paying a judgment. I'll give you an example. I have a client right now who I'm helping who bought a property from someone who did not adequately disclose some mold in the house. And he filed a lawsuit against the former seller of the property because it was eventually discovered that there were actions taken by the seller to hide the mold and hide the conditions in the property. I felt really bad for the guy, and that's why I took his case, because he, after going to closing, he spent $77,000 so far trying to abate this pervasive mold throughout the property. And he's still not completely clean in terms of the house and dealing with the mold. And he has to actually live in just one part of the property right now while he's abating the mold in the rest of the property. So that's the kind of thing that you're not providing insurance to somebody and filling out the disclosure, but you do have to disclose what you know or things that are readily apparent. And if you don't do that, you can be sued, and there usually isn't any insurance coverage that's going to cover you for the lawsuits that have been filed against you.
There we go. Yeah, which leads me to, I mean, what other pitfalls can happen in the probate process, and what are some bad things that happen?
Well, I mean, when you're dealing with probate, you know, there's some things that you don't want to do that seem common and obvious to people who are just going throughout their ordinary lives. You don't want to lie. You don't want to disinherit people. You don't want to avoid paying taxes. It's very tempting because if you're not experienced in this area, you might think, well, I can get away with not filing the inheritance tax return, especially if it's a cash deal, or I want this property for myself. and my brother or my sister or my other persons who could be heirs to this property, they don't need this property. They have a lot of money. Or mom would have wanted me to have the whole property to myself. When you sell properties and don't distribute money to people who are entitled to that money, or you hide a will, or you do anything to prevent somebody who should share in the inheritance, you could be sued. And that can present a lot of problems for you, not only the lawsuit itself, but there's other things that can happen too. If the developer buys a property and the developer is included in the lawsuit, you could be sued in a counterclaim by the developer, a cross claim, they call it. So by committing fraud or by disinheriting somebody intentionally, it could cost you a lot more than the cost of the lawsuit or the share of the inheritance that you're keeping from somebody. It could be catastrophic to your finances when litigation starts getting into all the things that can happen.
Yeah. What if heirs don't agree to sell, or what if one wants to buy everyone out? I mean, how does that kind of look like?
Well, there's a lot of different scenarios that can come up. So let's say that everyone knows that there's a will, but there is disagreement because of the will about exactly what should happen with the property. For example, let's say a grandmother passes away and she says, I want my 3 sons to have the property. Okay, great. But what exactly does that mean? Does that mean that their names are going to go on the title to the property? Does it mean that the property is going to be listed and sold? Does it mean that the heirs can come together and do a rehab of the property and then later sell it? Those are the kinds of things that result in disputes between the heirs to a property, because people have different financial situations, and some may want to hold out for the most amount of money by developing it first. Other people may wish to get the money quickly. And some people say things like, well, this property's been in our family for 40 years. Why would we want to sell it? We want to pass it along to our children. And so resolving those kinds of disputes and navigating them as a realtor or as an attorney can be challenging sometimes. There's always a solution to everything that can come up, but it's a question about getting people on board to do the right thing.
Yeah, which I guess reminds everyone to get their will in place to outline all this stuff.
Yeah, yeah, definitely. Having a will is important, and talking is important too. Sometimes, you can put everything you want on a document, but the best way to avoid a dispute is to head it off before it becomes a dispute. So if you're let's say you're a real estate agent and you want to talk about selling a property, encourage the heirs to talk to each other and get on board, because just talking can get people on the right page and eliminate suspicions if the family's not close to each other.
Yeah, a lot of ugly comes into a state I've seen when
Yeah,
heirs don't agree.
absolutely.
Yeah.
Kelly, can you tell us what would be expected from the buyer's inspections and any local municipalities' use and occupancy certificate obligations for the sellers or the estate?
Yeah, so good question. So if you sell a property, many townships and boroughs have what's called a use and occupancy inspection. So the transfer of sale will require the township or borough inspector to come out, and it has to meet their criteria. This is really specific to that location. So some don't have any inspection. So you'll want to figure out before you list, does our township have one? And if not, that's great. If it does, okay, are we going to make our house up to those codes, or are we going to make that a buyer responsibility? Same thing with a buyer inspection. A buyer, if you're accepting a traditional buyer and your terms are that the buyer's going to have an inspection, generally there's a window of about 10 to 12 days where the buyer can come in, perform their inspections. And if there's any findings that are safety or defective, they can come back and renegotiate the deal or terminate. So I never say the deal is not solid until after inspection period, if there is an inspection period. And also, if the buyer is financing, there's another layer of it has to appraise, and there might be, depending on the financing, the lender might require some repairs. So as a seller and the listing side, I would advise the estate up front, hey, if the buyer if you're listing it on the MLS, if the buyer is an FHA, a VA, or a USDA financing, you might not want to accept it, depending on the condition of the property. If the condition's fine, and we would go through that together, because they have stricter appraisal guidelines, they'll care about lead-based paint, tripping hazards, electrical things, etc. So upfront conversations with your agent of all the what ifs and what could happen in these stages is important, and just keeping in mind that the buyers generally will look for safety and defective items in their inspection. So you might want to make those repairs up front, or decide, hey, I don't feel like dealing with it, let's sell it as is to an investor.
One thing you
And
did say,
I meant to.
Kelly, can I ask you a question? One thing you did say is that sometimes the lenders will require repairs. Why would that be important to a lender?
Because they're basically owning the property, so they want to make sure it's up to their safety guidelines. So FHA, VA, and USDA are all government loans, so they make sure that it's safe, up to their safety precautions, and again, they want to make sure it's up to code for electrical items, tripping hazards, like I said, lead-based paint. So older homes, if it's before 1978 and you notice outside is all chipping and nasty, they're going to call it out. So they just care because they ultimately are the owners of the property.
Okay, makes a lot of sense.
Yeah. Slide. So on the flip side, on the buyer side, if you're looking to purchase an estate, you could potentially get a great deal, because if the state wants to sell it as is and for reduced costs and not make any repairs, or even if it's not in horrible shape, you might get a lower price. But as Michael kind of brought up before, if there's multiple heirs, and I've had this happen, some might not agree and some might be more stubborn and want a higher price. They might hold out for a little longer because they don't have a mortgage on the property, and they want to see if they can get top dollar, so they might not be as negotiable. So it really depends on the buyer side, and what to expect as a buyer during the inspection negotiations. Generally speaking, the estate wants a hassle-free as possible transaction, generally. So if you're gonna come back after inspections and ask for electrical, plumbing, roof, handyman, come do things, most likely they don't want to hire multiple contractors to come in and do this. They might not live locally. They might not have the means to do that. So as a buyer, your best bet is to ask for a seller assist or reduction in price, and you handle it after settlement, to make it a little easier on the estate, because they're likely not going to do all of that. And another expectation is, in negotiating up front, it might be good at you as a buyer to also check the township UNO requirements, because maybe you'll offer up front, hey, we'll handle getting that certificate done because we already plan on updating the kitchen and the bathroom, so we don't care about electrical. Just thinking outside the box a little bit, you might be able to get a little lower price if you're upfront to the estate saying, hey, well, we are willing to take on these potential repairs.
Okay, great. That's good insight. Good.
I know we're coming up on time. Does anyone have any questions so far that we've gone through?
Hey, Michael, if you're the executor of an estate, is there any time that you're not allowed to sell the property? I guess if there's not a will, is there a time where you become the executor, but you might not be able to sell it for, 3 to 6 months, when I guess you're trying to determine, who does own the property, or who can sell the property, I mean?
Yeah, so, the first thing is to find out, as you said, to find out if there's a will. And if there is a will, the will should say who is going to get the property. And that makes it a lot easier. as the executor, you have the duty to turn the property over to the person who is the heir to the property according to the will. If there's not a will, then it's also pretty clear because everyone has an estate plan, whether they realize it or not. Pennsylvania has a basic law that says exactly who gets what in what percentages if there is no will. So, you know, for example, if you are married and there's children and there's no will, there's this provision that says that the first $30,000 of an estate goes to the spouse, and then there is a split of the remaining amounts between the children of the person who passed and the spouse. If you don't like that, you should have a will because that's what's going to happen with your property afterward, and your house would be included. And if you're splitting an estate like that has primarily a house as the only asset or the main asset, the property is going to have to be sold, or people are going to have to buy out the other persons in order to allow that property to go to just to one person. So to answer your question, Andrew, is there a waiting time? Well, it's mostly about determining what are the rights of everybody who are claiming inheritance rights to the property. Once you figure out what that is, it's just a matter of making sure the taxes are paid, properly opening the estate, but there isn't any barrier to selling the property.
Okay, sounds good. Thank you.
Thank you for the question. Any other questions?
Are
Okay,
there any
great.
other legal or financial pitfalls that we should keep an eye out when buying them and buying
Yeah,
them here?
absolutely. Sometimes people, you know, we've been focused primarily on sellers today of estate properties, but sometimes people, you know, on the other side of this, there's buyers who want to invest in estate properties because, like Kelly told us earlier, you can buy properties from families who are heirs and potentially get a very good deal. And you can flip that property, you can fix and flip the property, you can sell it to another investor and profit on those deals. But there also, you know, the reason why you can get these properties at a discount is because there's also some pitfalls. And I'll tell you two quick pitfalls if you're interested in buying and selling these properties. One is to make sure you understand what you're buying. We talked about sellers' disclosures earlier, and you certainly, if you're on the sell side, you need to disclose things, but properties can be sold as is. And if you don't do your homework and take a very close eye on what you are purchasing, you can be on the hook for whatever the problems are with the property. The second thing that hooks a lot of new investors who are doing their first or second purchase is not understanding the legal title. So always have a title search done if you're buying a property. A title search is when you hire a title company for a few $100s to do a check on all the liens, the debts against the property, and claims by other people who might say that they have an interest in the property. That can save you a lot of heartache because, you know, I have helped people in the past who have known about liens when they purchased the property, but they made a mistake. You know, for example, they might think, well, the mortgage against the property or this loan against the property, we think it's $50,000, and it turns out maybe it's $100,000, and that might make any profit you think you're going to get zero because of your misunderstanding about what the amount of the lien is. So always have a title search done as well. Those are the two tips I would give people because they're the most common mistake that are made by new investors with inheritance properties.
Yeah, which is, I had this come up too on the sell side. They didn't realize, hey, mom took out a equity line a couple of years ago, so that had to be paid off. So even on the flip side, you need to make sure, you know, all the liens on the property and that taxes are paid too.
Oh, most definitely. Is there any other questions that I can address before we do the last thing that I wanted to do, which is share my resource that I have for you? Any other questions?
Hi, good day. This is Sophia. Thank you so much for this call and the information. I have a question about, I'm a real estate agent. What happens, say, like, we're in the middle of a transaction and, or like midway through selling a property, and family come out of the woodworks, but like settlement is scheduled, title's cleared, everything is good to go. How do we navigate those type of situations?
Kelly, that's a great question for you. Why don't you address that from the transaction side of it?
What do you mean they came out of the woodwork? Like, are they part of the estate?
Yeah, so this didn't happen to me personally, but in our office, we started receiving calls. I was doing floor time, so that's how I know this happened. We started receiving calls from family members from out of state,
Yeah.
um, and they wanted to stop the sale from happening. But I mean, the sale was literally going to happen in like days.
Well, unless they are heirs or have a legal right, they can't do anything. I even had this happen where the whole family, like all the kids wanted to come to settlement and had to stay, but ultimately only one person has to sign and has like the executor, unless there's multiple that the will states. I mean, it's kind of a legal question, right? Because you have to prove that
Right.
they have any right. They don't, if they don't have any legal right. It's a
But if
family dispute then.
they were the
It's not a
executor, but
legal
maybe
dispute.
the will had extra language that maybe the executor was ignoring.
Well, yeah, that's a problem if the executor is ignoring somebody. To address your question, like you said, well, what happens when they come out of the woodwork? The answer is that an administrator, if that person was properly appointed, has the right to administer the estate. So if they're making telephone calls to your real estate office, that's not the same as filing a legal action. It's not the same as filing a lis pendens or doing a will contest or things like that. So, I'm not going to give you legal advice about a particular situation, but just generally speaking, only legal actions can stop a sale that from going to closing, or a title company if they hear about something and they become nervous about it, or a lender becomes nervous about it. But generally speaking, you don't have to worry about it unless the person hires an attorney and actually takes some action.
Thank you.
Can they take action after settlement?
It's happened. Yeah.
Yeah.
It's happened. I have had matters where someone, they actually didn't tell anyone involved that there were other heirs to the estate. Obviously, because they want to keep the property for themselves and keep all the proceeds of the sale. The property did close. It went to a developer. And then they find out a couple months later that the heirs find out, hey, the property was sold, and it was sold for a lot less than market value. And oh, by the way, I didn't get any of my inheritance or any of my brothers and sisters. What happened? And so then a lawsuit's filed against everybody who's involved, including the buyer. And the idea is to stop the sale, prevent anything happening with the property until the dispute is sorted out. So absolutely, it can happen. Okay, very good. So thank you everyone for joining us today. I want to share something with you today. I have a resource that I think is very helpful to people who are in the real estate business, and it's called the Real Estate Resource Portal. And I send out real estate guides each month to people who are in my distribution list. But for today, I've just prepared a new guide. It's a 12-page guide that has a lot of different topics about the real estate industry, common disputes, and probate properties. And I think it'll be very helpful to you if you are an administrator or you're involved in the real estate business in any way. So if you're interested in receiving it, just send a message in the group chat here with your email address. And after the call, I'll be happy to send a copy to you. It's no charge, of course. It's free and there's no spam. So if you're interested in learning more about real estate disputes, I'd be happy to share that with you.
Thanks.
Okay, great. Well, thank you all for coming on today. If you have any questions about any issues that come up and you would like the assistance of Kelly or myself in resolving any problems that come up, feel free to reach out to us. My information's online. You can just Google Michael Daiello. My name is here in the participants list and the Zoom link, and Kelly's is as well. So we'd be happy to help you in any way we can.
Share this.
Kelly, anything else before we close today?
No, thanks guys for attending. Let us know if there's anything we can do.
Okay,
Love
great.
to hear from you.
Thank you.
Thanks
Have
a
great
lot.
day,
Thank you.
everyone.